In the ongoing New York civil fraud case against former President Donald Trump, legal experts have been closely examining the proceedings and the key players involved. In this article, we will delve into the developments of the first 2 weeks of the trial, featuring both insider and outsider witnesses who have provided crucial insights into the alleged persistent fraud at the core of the case. The New York Attorney General's office has been working diligently to prove this persistent fraud, which has already resulted in the establishment of one standalone count of persistent fraud 2 weeks ago. This case is particularly intriguing because it involves a multitude of individuals who are intricately connected to Trump's financial operations, thanks to a motion for summary judgment. One of the central figures in the trial is Allen Weisselberg, Trump's former chief financial officer, who has come under scrutiny for his actions. Weisselberg received a $2 million severance package, and the amount is quite suspicious, as it aligns precisely with the criminal fine he faced in his criminal tax evasion case. This raised concerns regarding potential obstruction of justice and perjury on Weisselberg's part. It's essential to examine whether this financial arrangement was designed to keep him from fully cooperating with the New York Attorney General's office, especially during his testimony. Another perplexing aspect of this case is the revelation of a 20% to 30% premium that Trump allegedly instructed his associates to add to the valuation of his assets. This creative accounting maneuver aimed to bridge the gap caused by Forbes magazine's discovery that his apartment was significantly smaller than he had claimed. The practice amounts to insurance and bank fraud, and it raises numerous questions about who was involved in this scheme and how it operated. Some may argue that the case is not overly complex. Experts in the legal field emphasize that Trump's actions in this situation do not warrant lengthy trials or extended preparation sessions. Despite what his legal team may assert, there is no reason for delay, and these cases should proceed as scheduled, both in March and May. Furthermore, the trial landscape features various cases related to Trump, but not all are equally intricate. For instance, the RICO criminal conspiracy case in Fulton County, Georgia, is considered one of the most complicated. However, Judge Tanya Schuin has been skillfully handling it, ensuring that it progresses efficiently. In Washington, D.C., before Judge Schuin, the case is also moving at an appropriate pace, with both sides receiving expedited treatment. In contrast, the Southern District of Florida's Judge Cannon has faced some peculiar interactions with Donald Trump's legal team. It appears that Trump's lawyers treat Judge Cannon with an unusual familiarity, suggesting that they may be seeking special favors, though this is not explicitly stated in court filings. The New York Attorney General's case, which entered its second week, remains a focal point. Although Trump's absence may have caused the trial to last only 2.5 days initially, it is vital to stay focused on the evidence presented each week to avoid the creation of false narratives. This week, Allen Weisselberg's testimony has garnered attention due to revelations about his severance agreement and its suspicious alignment with his criminal fine. If proven, this could have significant legal implications for Weisselberg. Additionally, the trial featured testimony from a former risk manager at Deutsche Bank, Nicholas Ha, who countered Trump's claims that the bank merely accepted his statements without question. This witness shed light on the due diligence process involved and how instances of fraud could have influenced loan decisions. Patrick Burney, a current Trump Organization member, also testified, further supporting the claim that brand premiums were artificially inflated on financial statements, which was allegedly directed by Trump himself. What is particularly noteworthy is the narrative's momentum in front of the trial judge, as the witnesses, both insider and outsider, present varying facets of the alleged fraud. The case began with Don Bender, a longtime accountant for Trump, providing insight into fraudulent activities that commenced in 2017. The revelation that Forbes magazine had discovered the true size of Trump's apartment led to the need for a financial sleight of hand involving brand premiums. Michael Cohen is expected to provide additional support for this claim, creating a coherent narrative for the prosecution. Weisselberg's lack of cooperation was a notable concern during the trial. When a witness deviates from their expected testimony, it signals a credibility problem. This may have triggered the punishment clause in their cooperation agreement. The legal experts underscore the importance of letting the evidence come to light and addressing issues during or after the hearing rather than preemptively dismissing a case or judge. It is expected to open doors to additional criminal cases against Trump and others involved, expanding the legal challenges he faces. Moreover, the case in New York is only the beginning. While Trump's absence may attract attention as a circus-like distraction, the evidence presented by witnesses remains a focal point for legal observers. This trial will likely have far-reaching implications, making it crucial to follow its progress closely.